This is Suchitra Vijayan, and you're joining us for the Polis Project's weekly politics podcast. Last year, the California Department of Fair Employment and Housing filed a lawsuit against Cisco on the grounds that a Dalit employee had been against, severely discriminated against by his upper caste supervisors. While the US does not specifically have laws against caste discrimination, the California government used a section of the historic Civil Rights Act which emerged out of African American struggle against segregation. This case has brought widespread attention to the issue of caste and Indian American identity in the United States. What makes this lawsuit historic is that it seeks the recognition of caste based discrimination under the American law. It is this demand, its implication, and the historical context under which it has emerged that is the focus of this episode. Joining us today are John Rushing and Karthikeyan Shanmugam. John Rushing is part of the legal team which filed the amicus curiae brief on behalf of the Ambedkar International Center in this case. He began his career as a litigator at the Sidley Austin LLP. S. Karthikeyan is an IT engineer living in Silicon Valley. He's one of the founding members of the Ambedkar King Study Circle in the US. Thank you so much for joining us today.
Very welcome.
Thank you. Welcome.
Mr. Karthikeyan, I'm going to start with you. The lawsuit against Cisco has brought the conversation on caste discrimination to mainstream American attention over the past year. However, this is not the first time the issue of caste is being publicly scrutinized in the United States. It follows a long history of struggle and activism, especially by organizations like the Ambedkar King Study Circle. Can you start by describing the 2017 California textbook controversy and why organizations like the Hindu American Foundation fought to erase information about caste system and its links to Hinduism in public school textbooks?
Yeah, sure. Thank you very much for having me in the program, Susitra, and very nice to see you, John, again here. Absolutely, you have started with the right question, that is erasing the factual information in the history books. What is happening in California is an extension of the Hindu extremist projects in India. You mentioned that it started in 2017. Actually, it started in 2006, and that is a continuation of the 2006 controversy in 2017. The aim of Hindu extremist group is to depict the Indian history or India as a monolithic entity, while denying her multicultural, multi-religious, multilinguistic characters, because that only serves their project of Hindu nationalism, and which is against the inclusive and plural nationalism born out of the struggle for Indian independence. Such a distortion of Indian history started during the colonial era, predominantly led by the Hindu Mahasabha then and the Muslim League, later continued and strengthened by the RSS, what we call Rashtriya Swayamsevak Sangh or National Voluntary Corps, which led the Sangh right-wing organization currently in India. The very right-wing organization, one way or another, connected with the Sangh family, that is RSS or VHP, the Vishwa Hindu Parishad, took up the task of distorting the Indian history in California textbook issue. They were completely defeated by the secular forces in 2016, and none of their edit accepted, especially their intervention on the social discrimination. But in 2017, they celebrated pseudo victory. Why I say the pseudo victory is that despite all their edit is refused, even after they mobilized 1,000 right-wing people to the public hearing, including the children, only one of their important edit is accepted. And I mentioned this edit because that is very much related to the Cisco alleged caste discrimination case. And the department agreed to remove that caste is not practiced in the USA, while accepting caste is a part of Hindu social order. The Cisco case and the testimonies collected by Ambedkar King Study Circle confirm the practice of caste in the USA. Our position is that what happened in Cisco, it's not an isolated incident, and also in other companies. It is an extension of practice of caste in the daily lives of the Hindus in the United States. And I would like to expand a little bit more why it is an extension is, if I would like to mention a couple of things, that how the practice of caste is uh, observed by the people from the so-called upper caste is the practice of casteist rituals, what they call as religious rituals. Still, there are some temples in Texas and Washington, D.C., which gives an advertisement. There is an casteist ritual function called Upanayanam, which is confined only to the Brahmin, Kshatriya, and Vaishya, the so-called upper caste children, which they will undergo. So this is how it continues.
Mr. Karthikeyan, can you follow up when you said about the edit made to the textbook? How was this edit possible, especially when it claims that Hinduism itself does not, well, Hinduism has caste, but there is no caste discrimination in the United States. Can you tell us more about this specific edit?
So before talking about this particular edict, the process how the textbook syllabus is formed in the United States, especially in California, is that they whenever there is a subject to be introduced, they will give it for the public opinion. And the Indian migrants were increasing since 1990s. Even before that, there are migration. There are increasing in 1990s, and in 1990, the California Department of Education introduced Indian history in the middle school, especially in sixth and seventh. And when they were given that time, it was not politicalized. What I mean is politicalized is it is not used for the political project of any political groups, but especially the rise of the Hindu right wing in the India, especially mid 90s, that they decided to take it up without distorting the plural character of India, and also by upholding the Brahminic or the Hindutva version of the Indian history, they cannot advance their project. And in that, they have seen two important futures. There are many, but two are very important. One is to show the non-Hindus as enemies of India, and the Hinduism itself is inclusive. So on the one hand, they deny the inclusiveness of all Indians. On the other hand, they are trying to depict the pseudo inclusion of all castes within Hinduism. And in this, the textbook rightly says and explains about the Hindu caste order as a social order, which is not comply with their project. So they decided without fighting it, and they cannot advance their project, and that's why they try to accept the caste discrimination, but it is the fact of the past, and currently it is not being followed. And especially they went to an extent and says the so-called untouchable should not be depicted as Dalits, because Dalits is a political term. Why you are teaching the history, and why you are using the modern term Dalit? So this is their design, diabolic design.
John, I quickly want to come to you and put this question to you. You filed an amicus brief on behalf of the Ambedkar International Center. In a recent press conference, you said that the lawsuit is historic because it's the first time caste discrimination has been raised as a ground for discrimination in American law. Can you elaborate on this and tell us about the significance of the lawsuit?
Sure. And Sakutra, thank you so much for having me. And Karthik, it's so nice to see you again. Let me kind of put this into a larger context. There have been disputes surrounding caste in the American legal framework before, but those disputes have never been raised to a level where law could actually be made and change the course of U.S. jurisprudence. That's for a number of reasons, not the least of which is the fact that many of these disputes have been handled through some sort of arbitration process and don't actually get into the courts, and so there's no chance for our case law to actually be changed or amended. Such is the nature, I guess, of arbitration. What's useful and interesting about this particular case is that it's the first time in American law that we actually have a test case that, if it is decided the way it should be, the way I think it should be, the way that we believe it should be, then it will most likely be appealed, and that appeal will change American law if it is upheld. Now you say, okay, but that's an appeal, and maybe we're talking years down the road as the appeals don't exactly happen right away. And the answer to that is sure, yeah, that's right. Appeals take a long time. So in terms of the overall process, yes, we may be looking at some time before an appellate court actually has a chance to look at this case and see that it was correctly decided when it is decided. But there's a very, very interesting aspect about this case, and it is this. Cisco has taken the position that caste discrimination is not illegal in California. In fact, that it is lawful. And in so doing, they have they have forced the court to make a ruling on that very issue. They've said, look, you've got to dismiss this. It's called a demur, and they're asking the court to dismiss these charges on the grounds that even if they are true, they're not illegal. Well, that's very exciting from a legal point of view, because it means that if the demur is denied, if the case continues, then a California judge will have recognized that as a matter of law, the state of California has an actionable claim for caste discrimination, and others can bring that claim. That will change California law, even without an appeal. And the reason it will is practical. It's not legal. And the practical reason is this. For the very first time, people will be able to say, look, this is an actionable claim under the law, and they will be incentivized to enforce their rights. And that's great. I think that this is an important civil rights issue. And once that happens, every tech company working in the United States that has any contact with California, because pretty much they all do, are going to have to retool and re-examine their HR practices related to caste. So yes, it is a historic case. It's a historic case because of the way it's positioned procedurally. It's a historic case because of the fact that Cisco has said this is not unlawful, and a judge is going to have to take a position on that. And it's a historic case because if the judge decides the way we believe the court should, then it's going to have a ripple effect throughout the tech industry, even before an appeal is taken. So I hope that's helpful.
I now want to kind of go back to you, Mr. Karthikeyan. You're someone who lives and works in the Silicon Valley. You're someone who has had a role in speaking up and also creating communities that are now struggling against these. Can you actually walk us through the details of the Cisco case in terms of how the case came about?
Yeah, I can do, but you want to do from the beginning. It started in 2016, actually. John Doe, who was alleged victim of this case, joined Cisco in 2015. Of course, he's recommended and recruited by this one of a supervisor who was allegedly practicing discrimination against him, Sundar, or Sundar Iyer. And things were fine till 2016. In 2016, Sundar outed John's caste. And how he came to know that John's caste is both went to the same school in Mumbai, the Mumbai IIT, both IIT Bombay, Mumbai. And when it is outed, Sundar outed a couple of their colleagues in the team. And John challenged it. What is the necessity to out somebody's caste? And it should have been settled in a very amicable way, because it is not so inevitable that the caste discussion pops up during our daily conversation. But Sundar took it offended and saying that he did not respond to it. Then John went and filed a complaint, and that he did not have a proper response from the HR, as a fact that, as John also explained, that Cisco HR's position was that caste discrimination is not unlawful. That was Cisco's position. I will cover later, and still that is their position. And he did not have enough response, so he approached the court. And not he approached the Department of Fair Employment and Housing, and who usually take up such cases, they will usually give a letter to the victim that you can go and fight legally in the court of law. But this case, interestingly, the department itself has taken the case and filed in the law summer, and later in the October they transferred to the state court. So here I would like to add one important point, that how the Cisco actually could have handled the case, but because it does not have an understanding of how the caste works, especially the social stigma attached to it, the case was dragged. In that, I would like to mention the four important factors to it. One is the dominant caste numerically outnumber the oppressed caste, is US in general and the tech industry in particular. And especially in the tech industry, the so-called upper caste people are in the firing and hiring position. And thirdly, the ignorance of caste among the non-South Asians, how the South Asians practiced caste, especially the whites and Latinos and other non-South Asians do not understand the practice of caste. And finally, and importantly, the continuation of social stigma which is attached to the caste. To expand it a little bit further, all dominant caste migrants, their path to the United States was via the education opportunities in India, which is long denied to the oppressed caste people. Their caste is the reason for their socioeconomic success, even though they typically ascribe to their merit. And here we would like to, I would like to emphasize on the merit, because on this very basis, that Sundar outed John's caste. And the merit implying that the oppressed castes are systematically denied the social mobility or lacking in ability. Many migrants from the oppressed caste, which have only been able to access higher education in India relatively, and recently, thanks to the affirmative action, what we call reservation in India, are comparative newcomers. They often find dominant caste people already in senior position with the powers to hire and fire and promote. This is the world that John Doe landed and encountered. And the caste system in the United States can be more covert and subtle as than in India, because of the fact I mentioned earlier. The South Asians, what they practice caste is not known to the non-South Asians, but the caste continues its perennial influence among the American Indians in all walks of life. Often, its effects are easier to hide from the public attention here, because the people, those who are not South Asian origin, rarely know about much about the caste and the way it is practiced.
And there's also an erasure, right, within the upper caste communities. The power to hire and fire also translates to capacity to shape the narrative. Very often, you would hear upper caste communities actually say that, oh, caste is no longer practiced. Maybe in the village, but not in the urban center. So that's also a key component of the erasure of, in addition to the power to hire and fire.
Exactly. So that is what I try to mean as the so-called upper caste people practiced caste among themselves on the one hand through the casteist rituals, especially the Superayanam, what I explained in the previous answer. Also, the temples openly says the Upanayanam is only for the so-called upper caste people of Brahmin, Kshatriya, and Vaishya. But on the other hand, they deny the existence of caste, and through that they build all their power and economical network. And also they did the same thing in India also, when the during the British time, they accepted British as long as the British is not intervening in the religious matters. When in the beginning of the 20th century, when the so-called oppressed people, especially the non-Brahmins, assert their cultural rights, especially the temple entry and all, the Brahmins try to show the 1858 Queen Victoria's proclamation that the British should not intervene in the cultural lives of India and Indians. So this dubious nature is the one which through which they continues the practice, and they are doing the same in the United States. There is no difference of their position in 1858 and to 2021.
John, I'm going to kind of come back to you. I have a series of questions for you. In the amicus curiae brief, you write, the amicus curiae brief says that American civil rights law has little experience with the South Asian caste system, but it is very familiar with the idea of caste. The notion that some people are born to a low station in life in which they are forced to remain. Of course, in this brief, you draw parallels between caste discrimination and race and color discrimination. How does the legacy of legal battles in civil rights and the struggle and those struggles do you think will help you think and fight this case?
But it's a great question. Thank you so much for it. Well, there's a historical answer and there's a practical answer. Historical answer ties into some of the legal framework for the 14th Amendment. And the practical answer has to do with activism. So let's talk about each. Historically, there is a treasure trove of congressional debate around the 14th Amendment and other actions that Congress has taken on civil rights that do have caste in the record. There are scholars that have done incredible work on the Congress of the 1800s and the way that they spoke about the threat of the 14th Amendment and what was perceived then as the threat of the 14th Amendment. And how they did talk about caste in the congressional record. Now, much of that has been lost to history and has not been at the top of this debate legally. So there's a rich academic literature that is available to advocates when engaging this issue. But more recently and more practically, the struggle of the American civil rights movement in the 20th century and now the 21st century, I think has direct parallels to what's going on here. It is no mistake that Justice Thurgood Marshall in 1988 wrote in a dissent in a Supreme Court case saying that the intent of the 14th Amendment was to abolish caste of all kinds. I'm paraphrasing. But that shouldn't be lost to lawyers and advocates and those engaged in the struggle. The fact that there have been hundreds of test cases in American civil rights law, some of which were successful, some which weren't, and the fact that this is not only a legal movement but a social movement that has to walk arm in arm together in that same way, pushing the law to do justice and at the same time raising awareness as you are here is incredibly important. And I think the parallels of this American civil rights struggle are clear. Also, Dr. King famously said that he too and all African Americans were untouchables. That wasn't lost on Dr. King. He certainly knew about the struggle of casteism in India, and he saw direct parallels to the American civil rights struggle. So I do think there are parallels. This particular case, I thought that it was one of those serendipitous little funny moments in life when the Ambedkar International Center first came to my law firm. It was Rosa Parks Day. And I remember looking at the calendar thinking, whatever happens, we have to take this case. This is an important landmark decision, and it's important to be in the fight. So I do think this is a historic case. I do think there are parallels to the American civil rights struggle. I think those parallels are both legal and activist. And on the activist front, I think that what you're doing and others raising awareness, making sure members of the community understand that this is profoundly un-American, that the law should not uphold this, and that it takes determination, resilience, and courage to fight back. And in so doing, I think that American law will change.
John, I have another question. This is very specific to one of the legal arguments that the amicus curiae brief makes. The brief also directly argues that caste can be understood legally under the framework of race and color-based discrimination. It states casteism is a form of race-based discrimination, in part because it poses a threat to South Asians. Again, in Bostock and Clayton County, the Supreme Court held that Title VII's prohibition on sex discrimination barred employees from discriminating against gay and transgendered workers because for these workers' gender, they would not face discrimination. The same reasoning applies here. If John Doe had not been a South Asian, he could not have been subject to caste discrimination. Could you talk to us more about this very particular legal argument you present in the brief and specific precedents that you build on? Because I think this is an important argument, and it's often can get lost in journalistic reporting of the case.
Sure. Yeah, thanks for bringing that up. So I want to start, let me just give you the three main arguments of the brief, and then we'll drill down and talk about this particular argument. First of all, this is not a case based on federal law, it's based on California law. And so the FEHA, which is the statute at issue here, is really our touchstone for determining whether the law has been followed or not. There are 14 or so characteristics that California prevents discrimination from occurring on. And in this case, I believe that 3 of those characteristics are squarely against Cisco. The first is ancestry discrimination. The state of California will not allow ancestry discrimination of any kind in employment. And casteism is clearly that. If you're born into a low caste, if you're born a Dalit, your children will be Dalit, their children will be Dalit. There's nothing you can do to change that. And so I think that legally the caste discrimination issue is clear. I think that caste discrimination is illegal in California because it is a form of ancestry discrimination. And for anyone to say, well, look, the statute doesn't say caste discrimination is really disingenuous. If the California state legislature had said, we're going to outlaw flowers with green stems that have thorns and red petals that smell good, then it wouldn't matter if they used the word rose or not. Rose would fall into that category. So we think that this demur by Cisco should be denied. In other words, the court should say, no, this case is moving forward. California recognizes this as a matter of law based on ancestry discrimination alone. We think it's a strong argument. But there are 2 other arguments that are also very strong. And one is race discrimination based on color, and the other is discrimination based on the heritage of the person. So the Title VII issue in Bostock versus Clayton County, I want, for the listeners, I want to give a little more framework of how federal law works and what that case was about and how the parallels are here. Most of, if not all, I think all of our civil rights legislation federally and much of the state civil rights legislation find their root ultimately in the 14th Amendment. The 14th Amendment is the amendment that says, look, the laws and privileges of the United States will not be abridged to any citizen. And from that particular amendment springs the 1964 Civil Rights Act, which was ultimately at issue in Bostock versus Clayton County, the Title VII legislation that came from that, and many of the state civil rights laws find similar language to the 1964 Civil Rights Act or Title VII issues, because there's no mistake. We're dealing with very similar concepts. Sometimes the Venn diagrams completely overlap, and in fact, the structure of the law is very similar. But state law and federal law are 2 different things. So while we're dealing with state law, looking to federal decisions can certainly be helpful and can help us sharpen and understand the argument. In Bostock, the Supreme Court held that Title VII prevented discrimination based on gender or sex because the statute mentioned the word sex. And so the question was, in terms of that fact pattern, what was really driving the discrimination? Was it driven based on the sex of the person or not? And the Supreme Court came up with a test. And basically the test is this: hold everything else the same, hold all things equal, don't change anything, change the sex of the person. Does the discrimination go away? And the answer is yes. And so the United States Supreme Court last year held that if you use a test like this, that discrimination, but for the fact that it was based on sex in that case, would not have happened. And so discriminating then against gay and transgendered workers in the United States is a violation of Title VII. That's basically the reasoning. And in this case, the similar reasoning applies. If you hold everything else equal in this case, and you change the fact that John Doe is South Asian, make him, for example, of Japanese heritage, this discrimination does not happen. And that's because all Dalits are South Asian. And this is unmistakably and fundamentally a discrimination that is based on race. It's based on his race as a South Asian individual. And so we think that under that reasoning, this case should be decided for John Doe, and the demur should be denied. The case should move forward. I know it's been a long answer, but I would be remiss if I didn't touch on the issue of color here, because this is also about color discrimination. And I feel like one of the things that I'm really grateful for has been the support of so many scholars and activists through the Ambedkar International Center in helping educate me, helping educate my firm about the intricacies and subtleties of caste discrimination. Because I think if you aren't South Asian or if you aren't from the Indian diaspora in some way, it can be really tricky to understand what you're looking at here. And it isn't lost on me that there are Dalits that may have lighter skin, but as a rule, darker skin pigmentation has been perceived as correlating to a lower caste. And because of this, I believe that the discrimination at issue in this case can be characterized as a violation of color discrimination. And I think that it would be a mistake to oversimplify the negatives and the intricacies of caste discrimination. I think that this is a complex issue, but I do believe that casteism is against the law in California because part of the way it's practiced has to do with discrimination based on the color of your skin. And the last thing to say is I think the parallels between Dr. King's struggle in the Jim Crow South and the struggle of Dalits to have a place in society here in America that is equal to people of lighter skin is unmistakable.
Thank you so much for that. We're coming to the end of the segment. So, Mr. Karthikeyan, I'm going to end with you with this question to you about this is a conversation that more people should have. This is about how when Hindus migrate, and Ambedkar wrote this almost 2 centuries ago, he said that if Hindus migrate to other regions on earth, Indian caste would become a world problem. Can you speak to us about ways in which caste has been transplanted to the United States within the diaspora, the way in which caste travels, spreads, and sustains itself in the diaspora?
The early migrants to the United States are from the so-called dominant caste people historically because they enjoyed the right to education, and not only that, they denied the right to education to the oppressed caste people. And once they migrated, their culture became the dominant culture. That's why when Mr. Vivekananda gave a talk in the United States, that he gave a talk as a representative of from the dominant caste angle, and which is believed that is the social life of India. It is very correct that caste is already a problem in the United States, and the solution we stand for is a legal protection, as John also touched upon that. But I would like to link with Dr. King's position and Dr. Ambedkar's position on this one. When Ambedkar says that if Hindus migrate to the other regions of the earth, the caste will become a world problem. And we see this is how the caste discrimination as the issue of justice. What Dr. King told, injustice anywhere is a threat to justice everywhere. And what we actually seeing from the casteist forces is a distortion of this very truth. They see justice anywhere is a threat to injustice everywhere. So that is what they try to replicate the social injustice in in India. They want to replicate in America also. And when the so-called oppressed people reach the code of law and other legislative, all the legal bodies for the justice, they see this is a threat to injustice. And in that's one that on that front we see the legal protection is the only means to save the oppressed people. And on the same token, when the caste discrimination is filed in the California federal court in July 2020, later transferred to the state court in October 2020, I would like to mention two things. One is in November 2020, the Mark Chandler, who is part of a Cisco legal team, wrote a blog in the Cisco site, which is called "The Protecting Our People," published in the Cisco blog itself. I quote Mr. Chandler from the very blog. He wrote, "We also do not believe we should be subject to claims either in court or in any arbitration for a form of alleged discrimination that is not legally recognized. We would, however, fully support the legislative adding the caste to the list of categories having protection against discrimination. It is what Mr. Chandler, who is executive part of a legal team in Cisco, writes. His position is same as Cisco's position from the beginning of that case. That is, that caste discrimination is not unlawful, and also protecting our people is very eluding one. I would like to mention one example why Cisco and their legal team do not understand caste, despite Mr. Chandler mentioned Mr. Wilkerson's caste, the origin of discontent in his very blog. After all this happening since 2016, in 2021, Cisco filed a motion in the court to reveal John's identity. This itself shows that the Cisco does not understand the social stigma attached to the caste. So, if the Cisco really understood the social stigma and how the caste operates, where Isabel Wilkerson very detailedly explains in her book Caste, and Cisco would not have gone and filed this motion to reveal the oppressed caste person's identity. Same, because their argument is the oppressor's identity also revealed. But meanwhile, we would like to appreciate one thing, that one point in his blog, that Cisco fully, I quote him, fully support the legislative adding the caste to the list of categories having protection against discrimination. So if it is a Cisco's position, I do not really know that what stops Cisco to deliver justice for John in this case. Also, the Hindu American Foundation filed a motion that they want to be a co-petitioner or they want to join in this case. And their argument is again, they again bring the liberty and the state. Their position is, this is something what the California court is intervening is their religious practice. It is the same position that the Hindutva takes all along the way, or the casteist people take all along the way. Any attack on caste is a tantamount to attack on Hinduism. And what they are telling, the court is intervening in their liberty. So I would like to quote here the US President Lincoln, who said in 1894, while he addressing the people in the Baltimore, the shepherd drives a wolf from the ship's throat, for which the ship thanks the shepherd as a liberator, while the wolf denounces for the same act as a destroyer of liberty, especially as the ship was a black one. Plainly, the ship and the wolf are not agreed upon the definition of the word liberty. This is the exact position of the case politically and historically, that the so-called untouchable or oppressed people and the castes and the dominated people do not agree on the definition of casteism and how it is being practiced. And we firmly stand that only the legal protection is a solution. And really, we among all the points that Mr. Chandler writes, we really appreciate that Cisco is also for the legal protection, and we are very open to work with Cisco on this going further.
I want to follow up on this religious issue because I do think this is an important thing for people to understand. Whatever the roots of casteism, and I think this is something that scholars can debate. I do understand, it is not lost on me, that in the Bhagavad Gita, caste is tied to the four varnas. I'm no religious scholar, and I certainly don't pretend to understand the intricacies of 3,000 years of Hindu theology. But I am a lawyer, and I do understand American law and California law in particular. And I think that whatever this supervisor's motivation was, is immaterial, because I do not think this has anything to do with religion. And it's important that people understand this point. The state of California prohibits discrimination based on ancestry, race, and color. And casteism is a form of discrimination that touches on ancestry, race, and color. It's as simple as that. And so, setting aside all concerns for motivation, the question is, in a private employer, can an individual discriminate based on ancestry, race, or color? And the answer is no. the law will not allow it. It violates the statute. And any private employer that supports a system that does that is violating the law. That is how simple this case is. And I think that while there is no doubt a very important conversation to be had among Hindus, among Indian Americans, among South Asians about where casteism comes from, how it's practiced, and pulling all of that apart culturally, that really is not an issue in this particular case. This is a straight violation of California law. So I just want to be clear for the listeners.
John, Mr. Karthikeyan, thank you so much for joining us today. We will be publishing the list of legal documents, other reference materials, and footnotes to this podcast. Thank you again for tuning in, and we wish you both the very best of luck. And hopefully, you will bring the change that is so desperately needed.